reminder that all folks that are participating on WebEx need to make sure that their cameras and microphones remain muted and turned off for the entirety of the proceedings. If we have any difficulties with folks repeatedly turning on cameras or unmuting, we'll have to expel you from the meeting. And then this is a reminder that all of the standard courtroom procedures apply even though you are participating remotely from WebEx. This should be treated as a formal court proceeding. With that, the Circuit Court of the State of Oregon for Multnomah County is now in session. The Honorable Benjamin Souede presiding.
Good morning, everyone. Is the state in a position to call these cases?
We are. I don't know why that surprises me every morning, Judge.
I can do it if you like.
Would you do it, Judge? I'm sorry, I don't have all three numbers.
I can do it. So good morning, everyone. We're on the record in three different cases. The first case is case number 19 CR 53042. That case is styled State of Oregon versus Joseph Owen Gibson. The second is case number 19 CR 53040. That case is styled State of Oregon versus Mackenzie William Lewis. And the third case is case number 19 CR 53035. That case is styled State of Oregon versus Russell Earl Schultz III. This is the fifth scheduled day for trial. All defendants are present, and good morning, Mr. Schultz, Mr. Lewis, and Mr. Gibson. They are out of custody. All counsel are present as well, both for the state and for defendants. We're outside the presence of the jury. I'll invite counsel to state their appearances.
Brad Kalbaugh, KALBAUGH 074335.
Thank you.
State.
Good morning, Your Honor. Also for the state, Sean Hughey, HUGH UI, bar number 152776.
Thank you, Mr. Hughey.
For Mr. Gibson, Attorney Angus Lee.
Brian Schultz for Mr. Schultz, 053726.
Ellie Doyle for Mr. Mackenzie Lewis, 840394.
Thank you to all counsel. I've been remiss up to now, and I want to fix that. I want to note that every lawyer and every defendant has been here right on time, ready to go just when the court has asked them to be here. It makes a huge difference in our ability to move this case forward. I take it seriously. I appreciate it very much. Okay, we at the end of yesterday, we agreed that today would be a law day. We try to get as many rulings that need to be made. So that once we start with the jury at 9 a.m. on Monday, we can proceed straight through and use the jury's time well. I think where that left us at the end of the day yesterday was with a number of evidentiary matters that need to be resolved related to various of Mr. Gibson's motions in limine. And then also the state had presented several oral motions in limine, and we agreed that we give the defendants time to formulate a response so that nobody was ambushed. Having done that, I am eager to proceed and to get those resolved. Does it make the most sense to start with the state's oral motions?
Yes, and we can give you an update on that, Your Honor.
I would appreciate it.
Okay, so of the three yesterday that they made, only one of them will remain after I finish talking.
Okay.
So going in reverse order, the issue, that's an issue any further.
Thank you for that explanation. Do I understand correctly, Mr. Hughey, then that motion in limine is withdrawn on the basis of that understanding?
Right. I think really the motion is just that any use of the grand jury transcript comply with the evidence code and 132270.
Okay. In that case, I'll grant the motion to the extent that it asks that the court follow Oregon law. Thank you for the explanation, Mr. Lee.
And when the court's ready, I can go to number 2.
Please do.
That was the OLCC report. We have no intention of marking or admitting the OLCC report.
Very well. I'll grant that motion as well as unopposed.
Yeah.
So that should just leave number 1 remaining. I can state my understanding of the motion, or they can restate it. And then
if you wouldn't mind restating it when you have a.
Yeah, the motion is really premised on the rule against irrelevant evidence and also 403 that would be without probative value and confusing to the jury, basically seeking to elicit testimony or introduce argument. I think the court described it as that people were selectively arrested or charged. Doesn't change any of the material facts relating to the elements of the crimes against these defendants.
Thank you, counsel. Mr. Lee, are you responding to this one?
Yes, we are objecting to that one, Your Honor. So there's a few reasons for the objection, and obviously there are issues of weight versus admissibility, and there are issues of how much admissibility there is. But our position is there is certainly an area of admissibility here to address issues of bias in any witness, which is always relevant, to address deficiency in police work or incompetency in police work, which is always relevant for impeachment, and to address motive. Now,
Motive or bias?
motive, well, both. I think they overlay with each other. And so we're relying on ER 609 and URC 4360.
URC?
ORS, sorry. Thank you.
Do that again.
ORS 4360.
Sorry, give me the ORS again.
That's a URC.
Is that just the motives? That's 609?
Yes,
Yeah.
same thing.
Yeah.
OEC 609.
Okay. So as impeachment.
Yes.
Okay.
Yeah. So, Your Honor, as I understand Detective Trainer's likely testimony, he's going to authenticate some videos that he found on the internet. And then he's also going to be asked a question along the lines of, why did you get involved in this case? Why were you investigating this case? And when we start talking about why a detective did something, the question of why can be probed. What is the full why? What is the full reason? And why did you conduct the investigation in the way you did? And what we have here is a detective who was not at the scene. He was not there at the scene. He did interviews after the fact, and he looked at videos after the fact. And what he did was he completed reports, and he selected who he would refer for prosecution and who he would not. And it goes to his bias that there were people and what I'm going to tell you is undeniable. There were people that are clearly engaged in violent conduct on the video that he knew the identity of, but did not refer them for prosecution. So 2 examples. In the video that you'll probably see parts of this morning and that you've seen before, there is an individual who clearly kicks Mr. Gibson in the groin. Clear as day, full soccer kick right in the groin. That person was identified. Detective Trainer knows who that person was. He has evidence of an assault against Mr. Gibson, but he did not send that anywhere for prosecution. The other one is the doorman for the Cider Bar is one of the people who got into that, the boxing match. Detective Trainer has video of that man clearly throwing punches at somebody, landing punches at somebody, knocking somebody to the ground, and Detective Trainer knows who that person is, discussed the fight with that person, yet took no action against him as well. And so the detective has this sea of people engaged in conduct of one level or another, and he has every legal ability to submit all of them to the prosecutor's office with a request for charges. And he didn't. He only picked those on one particular side. And go ahead.
I'm sorry, I'll let you finish.
And I'm not 100% certain how this comes into effect yet, because this is just new evidence that came to us in response to a subpoena. But we have an email that was sent to him, amongst others, from the mayor, talking about how the prosecution of these 5 individuals, these 3 and others, quote, had a chilling effect, end quote, on their political activity. So whether or not the detective was biased or selective in his enforcement for one reason or another, I think that's relevant for impeachment. I think there's a limit to how far we can go, and I think the jury can decide what weight to give to it.
Let me ask about its utility as impeachment evidence. To the extent, well, I don't know. I don't know what Detective Trainer is going to do. Right. If all he was going to do was say, I found these videos these are the videos I found, here we go. There's not much to impeach there, right? You're not no one's disputing that that's what happened.
Yeah, I totally appreciate the court's point. When I was thinking about this last night, the question in my mind to kind of, I think, ask the same question the court's asking is, if all he does is take the stand and said, here's 2 videos I found, they look like the videos I found on the internet, and then gets down, very limited impeachment, because he's not offering much to be impeached.
Exactly. Okay.
Um,
So would you agree that this turns somewhat on what it is, what the
turns-
direct testimony is?
Yes, and so here we're kind of in an information vacuum. So counsel for the state and I were had a productive discussion this morning to try and figure out what is the scope of his testimony, and they're telling me they're going to discuss why he was investigating this case, and then that opens up, why are you doing this, and why did you only do it to portions of them? Well, I was told to go look at, the Patriot Prayer people. You see what I'm saying? So, and that makes it difficult to rule now on the issue until we see what his full testimony is.
Okay. But to your mind, there is a world that we may be living in on Monday where that is a witness who is sort of subject to being impeached. And in your mind, this is the evidence. This evidence is meat for impeachment.
Yes.
Okay.
Yeah. Thank you, Your Honor.
Sure, Hughey.
Your Honor, I don't think we're ever going to get into that world. The only world where that would be admissible or that this evidence would be subject to being admissible would be where a completely different type of scenario where police responded to a scene, sorted out evidence, made a probable cause arrest of one person and not another. That wasn't like this at all. As the defense motions in limine that they have prevailed on have ensured, Detective Traynor cannot offer any conclusions about what's happening. He cannot narrate the video. So to say that we want to impeach his credibility on the things that we've already prevailed on keeping him from doing is not relevant. And more importantly, I think it's also excluded under Rule 403. It has no probative value on the elements on whether the defendants at this table committed the elements of riot if somebody else did too and was charged in another action or wasn't charged at all. And it absolutely has a high potential for confusing the issues to the jury. And that's exactly what the state's trying to avoid.
Okay. Thank you, Mr. Hughey. I'm going to defer on this motion. I do not know which world we're going to end up in. I agree largely with the state that if the testimony is as limited as the state believes, there may not be grounds for impeachment. That is to say, this evidence may not impeach on anything that this witness actually says. If things evolve differently, if he volunteers something, or if the testimony is broader than the state seems to think it will be, then I take Mr. Lee's point seriously, which is there may be an occasion for impeachment with this evidence. So I'm not going to give a ruling at this time, and we'll deal with it once we know what the trial record is.
My other then request in response to that would be that the court require any counsel to get leave to explore that area before attempting to do it in front of the jury.
I think that's appropriate. So let's make sure that it's brought to the court's attention and we deal with it outside the presence of the jury before any lawyer attempts to use such evidence for impeachment purposes.
Thank you, Your Honor. And I just wanted to, again, I'm not trying to step on
That's
Mr.
okay.
Hughey's toes. I've been talking to Detective Traynor yesterday just about when he's coming. He's got subpoenas from both sides, and he's going to be coming Monday. And that, after hearing Mr. Lee's presentation to the court, I think Mr. Lee may be making some assumptions that are inaccurate. That could be cleared up with either a 104 hearing or simply discussion with Detective Traynor about what he's going to say, which I'm sure he's happy to have. So if you wanted Mr. Lee, we could make sure that when he's here, we do a brief 104 hearing so that you could get some answers about some of the questions you have, which may help direct where this is going. I just wanted to offer that up for the court.
Okay,
so that
thank you. I don't know if we're going to, I think whether or not we need it will turn on what he says on direct.
Understood.
So it may be, I think the smartest order of things is have the direct decide if anybody thinks there's an issue. If anyone thinks there's an issue, we can perhaps do a 104 if that's productive and go from there. Okay, I appreciate the information, Mr. Kalbaugh. Mr. Doyle.
I may be at the wrong spot at the wrong time. But this case is charged as riot as opposed to incitement of riot. Is that correct?
The charge is what is in the indictment.
Which is riot and not incitement. And we have a large group of people on both sides doing stuff. I still remember when they had the two, and someone sprayed mace and someone else when they were having the mano a mano. I was talking to a friend of mine, and I said, "This is what happened." He said, "Boy, that must have hurt like heck." And so we have everybody sort of in a melee. Now, whether it's a riot or not is I guess, a question for the jury. But the 5 or more, it is our position that the 5 or more is caused more as much by whatever you want to call them, Antifa or whatever, as are caused by these 3 gentlemen. And I don't know what motion we should do or what time.
Mr. Doyle, I'll have an update for you. We can talk about that.
Okay, I'll be quiet.
All right,
Thank you.
Thank you. I'm happy to hear any motion when it is presented. Mr. Hughey, have we now addressed, to the state's mind, all of the motions that needed addressing?
I think we have. We briefly yesterday addressed the state's other motion about ensuring that any evidence or demonstrative be shared with the other side before its use. I know that was the court's order for all parties. If it's okay, I'd like to very briefly revisit Defendant Gibson's motion number 49, just to ensure that I'm clear on the scope of the court's order.
49?
Yep, this was the motion that our discussion really shifted over into prohibiting the use of any screenshots with narrative captions and video or arrows and demonstrative things like that the detective had prepared. But then when I reread my notes as I was generating the witness instructions, my notes say that essentially the motion
Accommodation to allow defendants to respond, but I did not intend to say, and I certainly did not intend to rule and have not ruled, that the fact that an exhibit was not included on the list renders that exhibit per se inadmissible.
I appreciate it. It might have been an overcautious clarification on my part, but I appreciate it nonetheless.
I'm glad we talked about that. Okay, have we now dealt with all of the state's oral motions?
I think we have.
Okay. All right.
We'll ask him in a break.
Could we just get a reaffirmation
It's going to be what
of
this
what
comes down to.
the state said yesterday, which is that they didn't anticipate any problems because they thought the list was complete and they understood the motion to be it was granted unless they happened to find some new exhibit. That's what I have in my notes as to how they interpreted it yesterday.
No, okay, so maybe my clarification wasn't overcautious. The exhibit list is a courtesy of what we anticipate to offer in trial. It does not close off anything else in discovery that's otherwise admissible from being offered. I have no problem with pausing, if there's an objection or someone needs to take a look at it to make an objection, but that is not.
It's more than a courtesy. It's an important instrument of efficiency through the course of the trial.
Absolutely.
But it is not the case that the mere fact that an exhibit was not on the state's exhibit list renders that exhibit per se inadmissible. It may be that we have to stop. It may be that we have to look. It may be that it may be subject to a motion. But it is not a per se bar to admission.
I understand, Your Honor. I was just trying to find out if Mr. Hughey was walking away from his representation yesterday, that he didn't anticipate a problem because he thought they were all there.
I think what I was saying yesterday was that we're certainly not offering detective trainers arrows or anything like that. And I do think all the exhibits that we're going to offer are on the list. But I don't think I'm legally bound by that if my mind changes tomorrow.
Okay.
Yeah.
All right. Known knowns, known unknowns, that sort of thing.
Sure. And is there a defense exhibit list forthcoming from Mr. Gibson?
Not yet.
The question. Okay. We would greatly appreciate that as an instrument for efficiency as soon as that would be practical.
as with the court, so that we can get this trial.
And I'll just, without a list, what I'll tell you is we're largely relying on the videos that you have listed in your exhibits, except for the 2 that have been withdrawn. The video that Mr. Buchal sent you yesterday, or not, he didn't send you yesterday, I referenced yesterday. And then we have exhibits here today to either mark or provide, but they're all impeachment. So they probably aren't necessarily, probably don't need to be listed on an exhibit list, but we'll probably provide them in advance.
Well, that would be, I think, a great time. We would love to have them on the fifth day of, our trial.
Impeachment exhibits?
Any exhibits, just,
Yeah.
and Judge, to the degree it's helpful,
Yep. Or I shouldn't have said exhibits, I should have said impeachment material.
since, and I appreciate counsel, I've been in trials where everyone offers their own version of the same video. That's really frustrating, and I think it's difficult for the jury, because then it's the same video, but maybe something's longer or something. So part of the reason we're having this hearing today is so that Your Honor can tell us if there's anything, redactions that need to be made, so that we can give it to our tech people to do all that stuff, to have exhibits, I don't want to say sanitized, but legally appropriate and admissible for Monday and Tuesday and Wednesday for the jury to deliberate with. And if there are other versions, we would really love to hash all those out today.
If I can suggest, I'm hopeful that we'll be done with jury instructions this morning, and then that should leave the parties the afternoon to confer and share exhibits unless the court has other matters for us.
No, we may not be done this morning, but my hope is that we're done as soon as we can be done. Let us turn to the exercise that Mr. Kalbaugh has identified. So the motions that have been deferred were 32, 38, 39, and 40. Motion 32